concerns we had about the specific language of the questions that were being asked. And Ms. Taylor represented to us, and I do not dispute this, that's why I want to make this part of the record, that she had not seen the actual questions themselves, that she had approved the topics that could be looked into during the survey. So I want to put that in the record that we are not accusing Ms. Taylor of drafting these questions verbatim and then say, go send these out to the public. We are concerned, though, that the people hired by the defense to conduct this survey did exactly that. And the examples of the things that are of concern can be found in the transcript of one of the calls. As Your Honor will recall, we had a person come to us who had received one of these calls, had actually recorded the call. And so our office prepared a transcript, and that was attached as Exhibit B, I believe, to our motion for order prohibiting contact. In addition to generic questions about the criminal justice system, here's where we get to things that concern the state immensely. Question: have you read, seen, or heard if Brian Kohberger was arrested at his parents' home in Pennsylvania? Question: have you read, seen, or heard if police found a knife sheath on the bed next to one of the victims? Question: have you read, seen, or heard that DNA found on the knife sheath was later matched to Brian Kohberger? Question: have you read, seen, or heard if Brian Kohberger owned the same type of car recorded on video driving in the neighborhood where the killings occurred? Have you seen, read, seen, or heard if the cell phone tower data showed that Brian Kohberger made several trips near the victim's home in the month before the killing? Have you read, seen, or heard if the university students in Moscow and their parents lived in fear until Brian Kohberger was arrested for the murders? Have you read, seen, or heard if Brian Kohberger said that he was out driving alone on the night of the murders? Have you read, seen, or heard if Brian Kohberger stalked one of the victims? Have you read, seen, or heard if Brian Kohberger had followed one of the victims on social media? Your Honor, there is absolutely no question but that those questions are disseminating by means of communication evidence expected to be presented, evidence that could be or would be inadmissible at trial. And I will say there are a number of these representations placed in the form of a question, but representations of fact that are not true or that would not be offered at trial. Or the performance or results of examination tests. And these questions specifically refer to DNA testing. Or the performance or results of examination tests. And these questions specifically refer to DNA testing. Now, I recognize that the defense says, well, all of this information is out there in the public media somewhere. But that misses the point. That's assuming that every person in Latah County who is called has followed all of this nonsense in social media, has followed extensive coverage. There are people who consciously avoid reading coverage or listening to coverage about this case because they don't want to. That's the fallacy of the position the defense is taking here. So what the agents of the defense have done is they have gone out and interrogated 400 citizens of Latah County and embedded in them facts specific to this case, some of which are not even true, some of which would not be admissible in court. And those people, whether they had heard that information before or not, are now saturated with that information. What the agents of the defense have done is they have gone out and interrogated 400 citizens of Latah County and embedded in them facts specific to this case, some of which are not even true, some of which would not be admissible in court. And those people, whether they had heard that information before or not, are now saturated with that information. That is exactly what the non-dissemination order was intended to prohibit. That is reckless conduct, and it's outrageous. That is reckless conduct, and it's outrageous. That is reckless conduct, and it's outrageous. They can ask a survey, and they can ask people, what do you know about the Brian Kohberger case? What have you heard about the Brian Kohberger case? What do you think about the Brian Kohberger case? Do you have an opinion as to whether he's guilty or not guilty? Why do you think that? They can ask all those questions, legitimate survey questions, if you wanted to do a legitimate survey of public sentiment. But these questions go far beyond that. And I recognize that that it is represented, that the survey questioning here in Latah County with those 400 residents has been completed, but they're already saying they want to take these questions out to other possible veneers. Doing the same thing in other potential jury pools that they're doing with our own. Doing the same thing in other potential jury pools that they're doing with our own. Doing the same thing in other potential jury pools that they're doing with our own. That is far beyond acceptable. These are questions that, quite frankly, might not be able to ask in voir dire, much less into an uncontrolled, unsupervised environment without any bounds, and just recklessly feeding this information, which is sensitive. And it's particularly sensitive when it comes to information that the state does not believe is true, or the state does not believe would be admissible or would be offered at trial. On the issue of whether information already publicly available isn't included in Your Honor's order, which it clearly is because it doesn't say otherwise, we know that there is no exception in the court's order saying if the information is already publicly known, it's okay to disseminate it again. And indeed, that would be reckless for the very reasons that I just articulated, Judge. And indeed, that would be reckless for the very reasons that I just articulated, Judge. We would then be feeding information that is potentially prejudicial or that could affect the open-mindedness of prospective jurors to people who may not have heard it before. That's completely reckless. That's completely reckless. That's completely reckless. And so, Your Honor, based on that, we think this needs to come to a stop. We think if the defense wants to continue doing survey work, which they are welcome to do, given what we've seen here, that the questions need to be approved by the court before they go out. And the question certainly should not include the types of questions, fact-specific questions that have been delivered to 400 citizens of Latah County. That's where we're standing right now, Judge. Thank you.
Thank you. So then how can we compare unless you use the same questions? That's the problem. I mean, the damage has been done.
Well, that's one argument to make, but we don't want to perpetuate the damage that was done. Well, that's one argument to make, but we don't want to perpetuate the damage that was done. And if they want to do a comparison, then they could have another survey in Latah County and do a responsible survey questionnaire. Instead of one tainting this people. Instead of one tainting this people. And frankly, they should ensure that they don't go to the same phone numbers that they preloaded with this other factual information when they make their legitimate survey inquiries. The defense's people brought this on themselves. The defense's people brought this on themselves. The defense's people brought this on themselves. It's not the state's fault. Nobody had control over this other than the folks working for the defense. They made their bed. They had to live with it. I mean, frankly, if we were in the commercial context, we would say, not only will you do this over and do it correctly, but we will not pay you for the work you did that was so outrageously wrong. That's not the context right here. I don't care about that. What I care about is making sure that more people aren't tainted. What I care about is making sure that more people aren't tainted. And I would suspect, Judge, as we move forward in this case, that the state will be asking the defense, and if they aren't willing to provide it, asking the court to order the defense to provide the identity of every person that was contacted in those surveys. So when we get to voir dire, we can identify people who have been contacted, I guess is the best word to describe, and faced with these questions. And so we can incorporate that into the questions during voir dire to see just how much impact, if any, it had on each one of those particular jurors. I don't know how else to deal with this. I realize
disqualified 40 people.
Well, we could 400. I realize
disqualified 40 people.
Well, we could 400.
400. That's what I meant. Sorry. Yeah. 400.
And we could do that. You know, Lake Tahoe County has almost 40,000 residents, although not all of those are going to be part of the jury panels, prospective jury panels, but 400 may be a reasonably small number. And yes, I think that certainly would be a viable solution, is just identify those people. We can certainly identify them by telephone number it was called, and just not include them on the list.
Since you're standing up, you want to talk about due process?
Actually, Mr. Nye is the one prepared to talk about due process, and that's why he's on. He's available by Zoom. If you'd like to have that now, that would be good.
I'll come back to that.
Yes, sir. Thank you.